SJC-11787, Christopher S. Doyle v. Commonwealth.
Mr. Doyle, I gather we have you by telephone, is that correct?
Yes, sir. Good morning.
Oh, the sound is excellent. Okay. Unfortunately, we've not yet moved to video conferencing, but we'll get there. So audio conferencing is right now the best we can offer, but the audio is loud and clear. So you have 10 minutes, sir, and you may be heard.
Thank you very much. May it please the court, my name is Christopher Doyle. I am the appellant petitioner in this matter before you, Christopher S. Doyle versus the Commonwealth of Massachusetts. I'd like to thank you for giving me this opportunity to bring these matters before this court with the hopes of a decision regarding their merits, namely the legal and unconstitutional restraint in which I suffer in. Since the beginning of recorded history here in Western civilization, all laws have been able to maintain their authority and their power through their ability to ultimately impose punishments on individuals who violated them. The issuance of fair punishments and punishments that are not within the principles of fairness and contrary to the interest of justice are really at issue here. It boils down to my claims of a double jeopardy prima facie claim as well as duplicative punishments, all arising from one single criminal act.
Mr. Doyle, let me interrupt for a moment.
Sure.
You were convicted of breaking and entering, correct?
I was convicted for breaking and entering into a depository, sir.
And possession of burglar's tools.
Correct.
Now, those have always been viewed as two separate offenses. Is it your argument that they are constitutionally one and the same?
It is my argument that they are the same because in order to break into a depository, not just the breaking and entering, it is necessary for the utilization of tools if it's locked.
Okay.
Now, this is a specific type of an environment in which you're breaking into. It's manufactured, it's impenetrable, it's designed to withstand severe levels of abuse, and without the aid of a key to gain entry or without the aid of a combination to the locking mechanism that keeps these items secure in this depository, it is just physically impossible to gain entry into this depository. There are circumstances, I would say to the court, in where someone would attempt to break into a depository of this nature without the use of tools. And I would say that that a person attempting to do so might be under the influence of drugs or alcohol, or might be suffering from a diminished mental capacity, perhaps of a very low education. And if that was the situation, then it could happen. However, that there was no evidence of any of that being presented by the Commonwealth in this trial proceeding.
Is it also your claim that the sentence that was imposed when your probation was revoked is also barred by double jeopardy in these circumstances?
It is, sir. I believe under the due process analysis, the standards that were established in Gagnon versus Scarpelli, as well as Morrissey versus Brewer, which this court quoted in Commonwealth versus Durling, 407 Mass 108, there are specific requirements that need to be adhered to in a violation proceeding. One of those being you have to present the claim of the violation. Clearly, the record that was before every single proceeding since I endeavored on this showed the reason for the probation violation quoted as being a new arrest, and specifically uses the docket number of the breaking and entering as the cause. Because of that, my probation was revoked, and because there was a suspended sentence involved in that, the court has no discretion as to whether or not, at least to my understanding, whether or not they can impose the suspended sentence or not. From my belief, they have to do so.
It has always been the case that a condition of probation is that you not commit another crime, and that the commission of another crime is a violation of that probation, and if there was a suspended sentence, it would be imposed. That's never been viewed as a double jeopardy problem with regard to the new crime. Are you saying we should change our law?
I'm not saying you should change the law, sir. I believe that it is up to the court's discretion during a revocation hearing whether they revoke the probation or not. Given certain circumstances, such as mine, I was completely compliant with all my probation standards until this arrest. I made all of my meetings. I paid substantial fees. I worked full time. I had no dirty urines. I had nothing of the sort. So without those other instances present and being cause for the violation, the court did not have to choose to revoke my probation at that point. Because they chose to do so, the only established grounds for my revocation is the violation. And the violation is simply this new arrest of which I have not been convicted of at the point of my violation. So the court didn't have to revoke my probation, take away my physical liberty, and put me in jail. A separate court chose to do so, and it was not the court that initially imposed this sentence, and it was not the state that initially imposed this sentence on me, because they chose, the sentencing court, to give me a chance at at probation, at freedom, as long as I complied. And I was not found guilty of that crime at the point of my revocation.
And Mr. Doyle, it's Chief Justice Gantz. You brought a 211-3 petition.
Correct, sir.
And that's usually viewed as an appeal of last resort. Why should we not say that you should bring this as a direct appeal, either from your violation of probation proceeding and or any conviction that may arise from the breaking and entering?
Sir, I attempted to have these issues presented in my principal appeal. After my trial, as you know, it's the right... excuse me?
No, we haven't said anything.
Okay. I presented to have these issues presented in my principal appeal. My appellate attorney fought me tooth and nail for months and months and months, and basically said that my argument didn't have any merit, excuse me?
No, we haven't said anything.
I'm sorry, I can't hear you.
No, we haven't said anything.
Oh, I haven't said anything?
No, we have not.
Oh, okay, I'm sorry. So I attempted to have these presented. She fought me tooth or nail and basically said that, the tools they were separate crimes. And I've never said that they weren't separate. All I'm claiming is that the punishment was duplicative. And if there was an analysis and a review of the nature of the depository, and not being the expanded version of the term depository, but a real true depository, in order to break into it, the tools are necessary. So if a court would have some sort of hearing, that they would determine that. It's just, I feel it's just logic and common sense that you can't open up anything that is locked without the use of something else, especially something being this. Now, I attempted to bring this into my appeal again, and my appellate attorney refused to put it in. And at the last minute, about a month and a half before my appeal was to my oral argument was to happen, I said, I spent a lot of research on this. I'm a criminal. You're a lawyer. I understand what you don't think it's true. You have ethical responsibilities not to present issues to the court that may clog them up. However, I know that you need it is just common sense. So I want this in. If you don't put it in my appeal, I feel that it's central to it, then I'm going to file a motion with the clerk of the appeals court and ask them to appoint me new counsel so we can postpone the oral argument and I can have these issues introduced into my appellate brief. And in the alternative, I would ask the court to allow me to argue it myself.
All right. Are there any further questions from the court, because his time is otherwise up? And hearing none, Mr. Doyle, thank you.
Oh.
And now we'll hear from Mr. Sears.
Good morning, Your Honor. May it please the Court, Matt Sears on behalf of the Commonwealth. The only issue before the Court is whether or not the single justice abused
Could I just interrupt for 1 second? I want to make sure Mr. Doyle can still hear. Can you?
Yes, ma'am. Thank you.
Okay.
The only issue before this Court is whether the single justice abused his discretion in denying the petitioner's petition pursuant to 211.3 because the petitioner at that time had an adequate appellate remedy or an adequate remedy in the usual course of review. He did not abuse his discretion. Unless Your Honors have any further questions, I'll rest on my brief.
All right, thank you.
Thank you.